Joining me now, Dahlia Litwick, legal correspondent for Slate and host of the Amicus podcast, and Glenn Kirshner, former federal prosecutor and host of the Justice Matters podcast. Both are MSNBC analysts. So, Glenn, some are calling the upcoming case of Moore v. Harper the greatest threat to U.S. democracy since the January 6th insurrection. Can you explain to our viewers what that case is about and why it could be so consequential?
Yeah, Charles, after the parade of horribles, the lowlights that you just highlighted with respect to some of these horrific Supreme Court rulings we are all now sort of suffering with, it looks like they're going to have an opportunity to see just how much power a state legislature should have. Is it unfettered power? Is it unreviewable by state courts? And, you know, they give it a fancy name. They call it the Independent State Legislature Doctrine. But if there was truth in advertising, they should call it what it really is. It is the fake elector doctrine. Because if they rule that state legislatures are basically kings of the state kingdom, unreviewable election decisions, that will give the Supreme Court the opportunity to give Donald Trump's attempted coup a retroactive thumbs up. And I don't know that our democracy can survive another go-round like we've just been through.
Dahlia, as Glenn points out, this would basically shift control of calling elections into the hand of state legislatures, many of whom are the people who are erecting the voter suppression laws in the first place. What are some of the other key cases that the Supreme Court will hear beginning in October?
There's so much, Charles, and I think, as Glenn suggests, we're still so gobsmacked by what we've absorbed that we almost don't know what's coming. What's coming, in addition to Moore, the independent state legislature's case, is a challenge to affirmative action in higher education that probably will be the death knell for affirmative action. Clean Water Act case that might do the same thing to the Clean Water Act that we just saw done to the EPA's attempt to regulate carbon emissions. We also have a follow-on case to the cake baker case where, you may recall, a cake baker didn't want to bake a cake to solemnize a same-sex wedding. We now have a web designer who's making the same claims, but making those claims in front of a very, very different court that tends to favor religious liberty overall. That's just a smattering of what's coming, and we have the court's barely started to fill its docket for next term.
Glenn, the abortion case is essentially a privacy case. What is the future of privacy rights in a post-Roe world?
Oh, I think privacy rights will be all but abolished, whether it's gay marriage, whether it's interracial marriage, which I think might qualify as irony for Justice Thomas, whether it's contraception, and I don't believe for a minute they're not going to come after desegregation. But here's the thing, Charles, we don't have to sit here and take the punches. You know, that's what it looks like and it feels like we're doing. But I'm reminded of an old political slogan that we of a certain age will all remember. It always struck me as a little vulgar, but it's the economy, stupid. Well, I think in 2022, it's the democracy, stupid. And if we don't go on the attack, full frontal assault of the Supreme Court, nonviolent assault, of course, but on two fronts. One is Congress should be gaveling open impeachment inquiries, because we know that judges, in their zeal to become justices, deceived the American people in the way they answered questions, not only under oath publicly, but behind closed doors. I'm betting if we issued subpoenas to the people that they spoke with about what they really thought about Roe v. Wade. You know, the judges take an oath, and they swear that they take that oath without mental reservation or purpose of evasion. And some of these judges did nothing but evade. They were evasive. And we need to at least open hearings to explore Clarence Thomas's conflict, the potential deception by judges in their zeal to become justices, knowing that at the earliest opportunity, they would overrule women's privacy rights when all the while they were answering questions to convey nothing to worry about here because to me, Roe is settled precedent worthy of respect. We need to go on the attack. We also need to try to add justices, which may ultimately require a supermajority in Congress. But we need to go on the attack. We can't just keep taking these punches.
I think I agree with Glenn's point that we need to go on the Democrats need to go on the attack. But also, does this mean that Republicans will also start to go on the attack? And what I mean by that, does what Thomas said in particular, in his opinion, incentivize a whole slew of new cases to be filed on the local and state level, hoping that they will rise to the point of making the Supreme Court take those cases and decide those cases?
Absolutely, Charles. I think it's clear it's already happening. There's funny language both in Justice Alito's majority opinion in the abortion case and also an attempt by Brett Kavanaugh to cabin the decision to say it's not going to go beyond abortion. And already we are seeing state elected officials in Texas and other places saying, OK, we're ready. We're going to challenge not just marriage equality, not just Obergefell. We're going to go ahead and start to launch challenges to Lawrence versus Texas, simply the right to same-sex intimacy without the government intervention. And I think we're going to also see, we're again already seeing states that are saying that contraception, what you and I and medicine knows to be birth control, is also triggering abortions, and states saying, you know, Plan B, the morning after pill, things that are absolutely have nothing to do with the doctrine we saw in Dobbs. All that stuff is on the table, too. So I think you're exactly right. Justice Thomas at least was honest in his concurrence and said, if you pull out substantive due process and unenumerated right, everything else is really subject to attack, and we are already seeing that happen a week after Dobbs.
Glenn, I just wanted to pull back a little bit and take in the big picture. What do you think the impact of this court long term will be on American democracy as we know it?
You know, given that so many of their opinions seem to be either overtly based in religion or sort of very thinly veiled, religiously driven opinions. You know, it really does feel like they view the Constitution as little more than a codicil to the Bible. You know, I think it is going to threaten everyone because, you know, when you look at the decisions like school prayer, right, where coaches and teachers can, on public property, lead students in prayer. And Charles, that is de facto coercive of the students who either don't share the religion with their teacher or their coach, or even if they do, they don't choose to make a big splashy public display of it. They choose to do it in private. I think it ultimately threatens everyone's right to practice whatever religion they choose or no religion at all. And with, you know, the religious schools, which can now, you know, get our U.S. tax dollars, or the school prayer case, or Roe v. Wade, which let's not say we can extract the religious undertones of that from the opinion, it threatens everybody. And I think, you know, there is no stopping these Supreme Court justices. The way we have to get at it is by just kind of attacking the problem head on, trying to pull it out by the root, and, you know, have the kind of public hearings that expose all of this for what it is.